Hi, everyone. Good morning to participants and good evening to our presenters. Thank you for joining us today. I'm Amelia Lancaster, co-chair of the International Committee for the San Francisco Bay Area chapter of the ACC. And today we are going to talk about operating in India, considerations for in-house counsel. We welcome all of you as members of the ACC, whether you are based in the Bay Area or elsewhere, and extend a very special thank you to Maj Mujar and Partners for hosting this webinar. First, we have a few housekeeping items. This session is being recorded and all attendees are on mute. You can direct questions to everyone in the chat box at the bottom of the screen, which will be answered at the end of the presentation. If by chance your question isn't answered, we welcome you to reach out to our presenter, Rukshad Davar, for more information. You're now going to have a poll in which you can opt to share your email address with our presenter and to join Maj Mujar's email listserv. The ACC will send copies of this presentation and a survey in the coming days, along with CLE certificate for those registered in California. If you have registered for CLE credit in another state, please check in with us regarding the steps to get your CLE certificate. I'll now introduce our speaker, Rukshad Davar, who is a partner and head of the M&A practice group at Maj Mujar and Partners. He focuses on mergers and acquisitions, inbound investments, restructurings, joint ventures, corporate and commercial matters, commercial and antitrust matters, and direct tax. Rukshad has over 23 years experience in these matters, and he successfully led and advised on complex domestic and cross-border mergers, acquisitions, restructurings, joint ventures, strategic investments, asset sales and purchases, slump sales and hive-offs, corporate advisory and direct tax and treaty matters. He was previously with Jones Day. We welcome Rukshad and thank you again for joining.
Thanks, Amelia. Thanks, Amelia, for the introduction and welcome everybody. Good morning to all of y'all, and I'm sure this will be an informative session for everyone who is signed up for this. And I'll try and make it as informative as possible, given it's the early start to the morning. So thanks everyone once again, and let me just quickly dive into the presentation in terms of just highlighting the key statistics in terms of the M&A activity in India. So we have seen a consistent a steady year-on-year increase in the percentage of FDI, that's foreign direct investments into India, although there was a blip a bit in the last year due to the pandemic, but it's well made up for it, and we are continuing to see a very, very buoyant period in terms of the M&A landscape in India, both not only in the public M&A space, but also in the private M&A space. So in fact, the deal flow is in a frenzy right now. So we are seeing a lot of deals happening across different sectors. And of course, as a law firm, we are pretty sector agnostic. And although we are seeing a lot of deals happening in the tech space, and now we are seeing a lot of activity happening in terms of acqui-hire transactions, which is kind of a flavor of the season right now in terms of picking up out the human resources which are required for the client's operations in India. So there are, there are certain preferred states for which have attracted foreign direct investments in India. To name a few: Gujarat, Maharashtra, that's where we are situated in Mumbai, Karnataka. Those are the top three states that attract FDI in India. The services sector and the computer software and the hardware sector continues to be the strongest sector attracting foreign direct investment in India. What we have seen is that historically and even now, US is the largest contributor to FDI in India, whether directly or indirectly through intermittent tax jurisdictions. Earlier, we used to have Mauritius and Singapore being preferred jurisdictions for routing investments, but now we are tending to see other jurisdictions as well. I'll move on to the next slide. I think an important aspect to keep in mind whilst really operating in India or doing business in India is the cultural issues and certain mindsets of Indian personnel that you would be dealing with. So we have thought it fit to just introduce one slide so that we can give you a quick snapshot as to what are the key cultural issues that you all need to be mindful about. So the first important point is that most businesses are traditionally run. They are not professionally managed, as you would expect it in the West and more particularly in the US. Although nowadays companies which are listed and which are in the bulge bracket, they are being professionally managed because they attract a lot of institutional investments, so they have to move towards professional management. But a lot of the companies are still historic promoter owned, Indian dominated owned and controlled companies, which may be a little relaxed in terms of being professionally managed. So that's something that you guys need to keep in mind. The business structures are pretty hierarchical, and what we've seen is that decision making is still at the top level. So a point to be noted is that that when you are negotiating with Indian parties, I think having the decision being vetted and having the key points being discussed by the person really signing off on those points is very critical and key. Otherwise, I mean, things can go in circles and it can be a quite a frustrating process. The tendency is, people are polite out here, so in I mean, in quite a few situations, people would say yes in order to be polite, but please note that the yes does not mean a yes, so you could, I mean, be in for certain unpleasant surprises, in terms of what we have seen is that the expectations of the West in terms of the way documents are turned around and all of that, timelines can be a little relaxed from Indian counterparts, so we need to keep in mind of that front as well. Also, what you need to keep in mind is that the compliance levels are not up to the mark of the West, and certain corporate and employment compliances can be a bit haywire, but of course those can be ironed out consequent to due diligences and prior to the consummation of the transaction. So if we are looking at buying out an Indian business, if a non-resident entity is looking out to buy out an Indian business, we've set out certain points that need to be kept in mind to have a deal going forward. What we should keep in mind is that the Indian counterparts always want a premium, okay, over the price, okay, or over the multiple that is in place in the market. What we have seen is that for the transitionary phase, in the key managerial personnel are employed, in the business. And of course, in certain transactions, we have seen that a key convincing factor for a buyout would be lack of successor interest. So that would be a good point on really moving the deal forward, and we've seen that play out very well in terms of acquisition of targets in India. Conversely, I mean, if we are exiting from the business, be prepared to take a bit of a haircut, in terms of the price multiples. And of course, another point to bear in mind is that there are certain compliances in terms of forms to be filled out, not very cumbersome, but those will be applicable if a non-resident is selling the stake to a resident investor. But conversely, it would not be applicable if the non-resident, that is a US investor, was to exit and in turn sell its stake to another non-resident entity. So preferably, if there is a non-resident entity in place, certain compliances would be reduced from an Indian standpoint. So that can be kept in mind as well. So moving on to the next slide, there are certain key regulations that we need to keep in mind for foreign investment into India, and certain laws which are quite important to really navigate through whilst doing business in India. So those are the Foreign Exchange Management Act, the FDI policy, that's the Foreign Direct Investment policy. The Companies Act, which regulates corporations and limited liability partnerships in India. The Insolvency and Bankruptcy Code, which of course deals with situations of insolvency and how to reconstruct and resurrect the company in terms of non-payment of debts. The Security and Exchange Board of India regulations, that is the Security and Exchange Board is akin to the SEC in the US, which regulates listed entities. So these regulations are more so to do with listed entities in India. So if we are engaging in a buyout of a publicly listed company, then the SEBI regulations, that's the Security and Exchange Board of India regulations, would come into play in a big way. The Competition Act is the antitrust regulations in India, which we need to keep in mind whilst doing M&A or restructuring transactions or even amalgamations in India. The good point is that in the antitrust regulations, which are fairly new in India, we have adopted the EU model and really based it on an international standard, which of course, amongst other things, also has the de minimis thresholds pretty high. So what we have seen that is it's only in the very large deals that we would need to notify and file before the Competition Commission of India, which is the antitrust regulator, and not otherwise. Another important legislation is the Indian Contract Act that's a very old legislation which really talks about principles of contracts and how to interpret contracts. The laws on anti-corruption, intellectual property, employment, and data privacy, which we will discuss in this presentation, also play a very, very key important role. And last but not the least is the tax legislations, including the double taxation avoidance agreements in between US and India, also assumes a lot of importance. So moving on to what are the different routes of entry into India? Okay, so there are different ways. Either you set up a liaison or a representative office or a branch office or a project office, or we can. What's the most preferred mode is either a private limited company or a limited liability partnership. So foreigners and foreign investors who merely want to test waters. Kind of at first, they may prefer to set up either a liaison office or a representative office or a branch office. But the activities are fairly limited that you can do in each of the situations, as well as in a project office. What you can do is very limited. And of course, funding has to take place from the head office, that is from the foreign jurisdiction. Also, you can't earn income in India in case of a liaison or a representative office. And also the most important key factor, which is a very big deterrent in terms of establishing a liaison or a representative office or a branch office, or as a matter of fact, even a project office in India, is that the tax rates would be high, and those would be applicable as to a foreign corporation doing directly business in India, which would roughly be about 44 to 45%, which would be the corporate tax rate, as opposed to a private limited company or a limited liability partnership, where the tax rates would be much, much less, because we are confining it to an Indian entity established in India. So the preferred mode is to establish either a private limited company or a limited liability partnership whilst doing business in India. But of course, that being said, if you are wanting to introspect and just merely test out waters, then for a month or two, we can have a liaison or any of those liaison or a branch office or a project office in place. But the point to be borne in mind is that for setting up either of those three types of entities, a prior approval from the Reserve Bank of India is required, which or the authorized dealer bank is required, which may not be forthcoming very soon in the time frame as what we would take to incorporate a private limited company or a limited liability partnership. So just delving a little further into the characteristics of a private limited company. So it's governed by the Companies Act. The liability can be liability limited by shares or guarantee, akin to C corps in the US, and they are separate legal entities having perpetual succession. Limited liability partnerships also are governed by the Limited Liability Partnerships Acts. Okay, again, they are a separate legal entity and they have perpetual succession. The members' liability is limited in terms of akin to a US, akin to a private limited company. So those are the different nuances between a private company and a limited liability partnership. I will come to the tax rates when we discuss the tax considerations in the later on slides. Now, just to discuss a very recent nuance that has come into being under the foreign exchange regulations in India is a press note which has been enacted about a year and a half ago. And this press note has come into being due to the then rising political tensions between India and China. So what it says is that if there are investments coming in from land bordering countries, which would also include China, of course, it's targeted towards China, but would also include Hong Kong, Taiwan, Bangladesh, Bhutan, and certain Afghanistan and certain neighboring countries. So if there are investments coming directly or indirectly by entities or persons resident in India, those would require prior approval from the government of India. Now, this holds good even in terms of cross-border acquisitions, like say if a US entity is to acquire an Indian business, but the US entity has foreign investment. Now, the view that we have adopted is that given the fact that the government has not come out with any clarifications on this, given that they don't want to dilute their position on this press note, the view that we are taking is that in terms of an indirect acquisition, we can live with thresholds of about 15 or 25% in terms of the navigating around this press note of 2020. But in terms of a direct acquisition, since we would need to file forms with the Indian regulator, then we would need to comply with this press note. I hope the government, we are all in hope that the government brings about some clarity on this press note. But even nevertheless, even with the existence of this, deals are active and people are investing in India. But unlike the CFIUS in the US, the press note 3 is sector agnostic, so it would apply across the board. I mean, it's not picking and choosing a particular sector for which this would apply. So it would apply to technology, pharma, insurance, life sciences, healthcare, any sector. So that's a bit of a nuance which is kind of made which we need to navigate whilst doing deals in India. Now coming on to the next slide, there are certain key sectors where foreign direct investment is prohibited, which includes casinos, betting, gambling, then real estate business, manufacturing of cigar, atomic energy, but of course, because of the government, sensitivities on that, and as well as railway transport. What I would want to mention is that ever since India has embarked on the path of globalization, our foreign investment policy has been liberalized by the government from time to time. And so today we are at a juncture where most of the sectors are open to foreign investment, and up to 100% foreign investment without the need of nodal government regulator approval for the purpose of foreign investment. Of course, we will need to obtain the licenses and permissions for doing business in India. But what I would say is that we have opened up the market very progressively in India. So only a few sectors remain I mean, subject to a certain threshold for foreign investments, which is the defense sector, where 74% is permitted under the automatic. What I mean by automatic route is that without the prior approval of the government of India, and above 74, you can invest, provided you demonstrate to the government that this investment is going to lead to state-of-the-art technology coming into India. Multi-brand retail trading is permitted up to 51%, but under the government route, whereas single brand retail trading is completely opened up. That's 100% foreign investment is allowed under the automatic route. For the pharma sector, 100% again for greenfield operations is completely permitted under the automatic route. 74% is permitted under the automatic route for brownfield investments, and beyond that, we would need government approval for brownfield investments. Insurance also has been progressively liberalized over the past couple of years, where we used to have foreign investment only limited to 26%. Then that bar moved up to 49%, and now we are at 74% with under the automatic route. So other than these couple of sectors, foreign investment is 100% permitted, as I mentioned, under the automatic route. What we need to keep in mind is that investments between NR, non-residents, and residents, and vice versa, residents to non-residents, where we are exchanging shares or securities, they have to comply with certain pricing guidelines and valuation methodologies. So valuations need to be done in India for those investments. Downstream investments are permitted, but with certain prescribed conditions. Issue of shares for non-cash considerations is also permitted, although it's regulated, but it's permitted. So we've seen deals happening where it's for non-cash consideration where shares are issued. So those are permitted. Swap of shares are permitted under the FDI policy. There is another rule that I would like to really delve upon. It's called the 1825 rule, which regulates deferred consideration and indemnity payouts. This is only for the, in terms of if there is a transaction between a non-resident to a resident, with a resident, or with a resident and a non-resident, vice versa. So what it says is that if there is a share transaction between a non-resident and a resident, we cannot defer the consideration for beyond 25% of the purchase price and for more than 18 months from the closing date. And if we are to do that, then we need prior approval of the authorized dealer bank or the Reserve Bank of India, and those are, and we've not seen those approvals being forthcoming. So as a via media and as a workaround on this route, what we are doing is that operational entities in India, if they acquire of non-residents in India, if they acquire the stake of the Indian partner, then that would not be caught under this route. So you could have a deferred consideration, as well as you could have escrows and all of that, not restricted to 25% or up to or not restricted to the 18-month period. So that's something that we need to bear in mind. We've seen operational entities of non-residents acquiring shares from of target entities. Those are not going to be subjected to this route. But if you are making a direct investment, then and if the contracting party is the US entity, then we will need to keep in mind this rule. So coming to certain investment strategies, the most adopted investment strategies are either doing an asset purchase or a slump sale, which is akin to a business purchase in the US parlance, or doing a share transaction. So in case of an asset purchase, it would be cherry picking of individual assets and liabilities. Slump sale would be more of a business undertaking on a going concern basis, which would be transferred for a lump sum consideration. And purchase of equity shares would be buying the entire entity as a whole. There are stamp duty implications in each of these modes. So stamp duty is a state subject, and it depends on and it varies from state to state in which the acquisition is consummated. And in stamp for an itemized sale, it would depend on the value of the assets being transferred. For the business, it would be the value of the entire business and the assets within that business. But for a share purchase, it would be less compared to the asset purchase and the stamp duty implications in case of a business transfer, which is very nominal, which is 0.015%. And also there will be an stamp duty on the purchase agreement, depending on the state in which the purchase agreement is executed. Now, in certain places like Maharashtra, we have an ad valorem stamp duty on the share purchase agreement. But then if say a counterpart or say another a target entity is situated in another state, then we would choose to really stamp it in that state. In terms of the indirect tax implication, that's the goods and service tax. That would be applicable in case of an asset purchase. It would not be applicable in terms of a slump sale or a share purchase transaction. Successor liability, which is very, very important, and it's often a concern for US entities. And that's why we have seen a lot of our deals being structured more as an asset purchase and a business transfer or slump sale rather than a share purchase, is that in case of an asset purchase or slump sale, we can carve out the liabilities and really limit the liability of the successor entity. That's the entity that we are buying into, which is not possible, which is not going to be possible if we are going to buy the shares, because we are going to buy into the whole entity as a whole. So in asset purchase and slump sales, yes, we can ring fence the liability, whereas in a share purchase, we would not be able to ring fence liability. So these are certain key points that we need to keep in mind for either of these options whilst doing an acquisition in India. Certain other points that we wanted to really highlight is that non-compete and non-solicit clauses in agreements, they are not valid beyond the term of the contract, but they would be valid for the term. So I think we follow the same principle as California law on these points. Confidentiality, we don't have a prescribed statute which grants protection for confidential information, but consistently courts have given comfort in terms of granting injunctions to uphold and to safeguard the protection of confidential information. For claiming damages, what we need to keep in mind is that Indian law allows direct losses to be claimable, and they are awarded, but not indirect and consequential losses. Liability can be limited and can be specified as a limitation of liability under contracts, but that would not be permitted by the court if there's a fundamental breach of the contract in terms of the substratum of the contract being violated or breached. Coming to data privacy, we do not have a specific data privacy legislation as yet. We have a draft in place, which we believe should be enacted very soon by the Parliament. But for now, the Information Technology Act regulates protection of sensitive personal data. So, and with privacy policies in place, which we mandate, to be done in consequent to an acquisition, there is protection of data being offered. Enforcement of foreign judgments and awards, that's another critical piece that needs to be kept in mind whilst really doing business in India. So what we need to keep in mind that vis-a-vis the US, foreign judgments are not going to be easily enforceable in India, which the judgments from a court in the US, without having to execute fresh proceedings, bring about fresh proceedings in India, because India is not a reciprocating territory for foreign judgments. But in terms of foreign arbitral awards, since we are a reciprocating country in terms of the Hague Convention, we for foreign arbitral awards, we would just merely need to file execution proceedings of a foreign arbitral award in India. Another key important point that needs to be kept in mind, not only for commercial contracts, but also for deal-related documents, is that we must confine the dispute resolution to an arbitration mechanism, given the laxity on the part of the courts in India, and given more so given the pandemic situations where there's been a lot of backlog being piled up, with the Indian courts. The most effective way of dispute and the most superior way of dispute resolution would be through the arbitration mechanism. Although I must say that we must provide for in the contract for either parties to approach courts in India to seek interim release, because what we have seen is that for interim reliefs, only for the purpose of interim reliefs, we've seen courts to be fairly well adaptive on that front, and they know they've seen instances of mischief on non-compete or confidentiality or violating shareholders agreement, where injunctions have been forthcoming in a pretty good time frame. Like I would say that we have done certain injunction where we've got it, like say in about 2 to 3 days time, which would not be possible if we were to resort to the arbitration mechanism, because we would first have to constitute the arbitral tribunal and then have an order passed through that arbitral tribunal. So that's an important point to keep in mind, that we should have the entire dispute being judged through an arbitration mechanism. But for interim reliefs, we should have the option to knock on the courts of competent jurisdiction to get those reliefs. Certain key tax considerations that we have really thought it fit to just highlight is that there has been the huge reduction in corporate tax rates for manufacturing companies which are incorporated after October 1, 2019, and they are taxed at a flat 15% tax rate. Existing manufacturing companies would be taxed at a flat rate of 22%. But the downside on this is that you can't claim any corporate deductions, any revenue deductions on this tax rate. Otherwise, I mean, if you were to claim deductions, then the normal corporation tax rate is 30%, which is the same as in case of a limited liability partnership, which is at about 31%. So that's something that we need to bear in mind whilst incorporating an entity or doing business in India. Now, in case of an asset purchase, of course, it's more of a seller tax consideration. The seller would be responsible for paying capital gains on the assets that are transferred to the purchaser. Slump sale, again, it's more of a seller liability issue. Again, the seller would be liable to pay a capital gains tax. But the differentiation point is that on the asset purchase route, they would need to pay capital gains on the transfer of each a value of itemized assets, whereas in case of a slum sale, it's on the net worth of the undertaking that the capital gains tax is calculated. Again, in a share purchase route, capital gains tax would be forthcoming and will be payable by the seller entity. Now, an important point to be considered is that well, we can explore certain beneficial provisions under the double taxation avoidance agreements files routing investments into India. So historically, we've seen investments coming in from the US through intermittent jurisdictions from Mauritius and Singapore into India. But now, with the Mauritius and the Singapore tax arbitrage coming to an end, we are seeing a good deal of investments coming from Netherlands, which offers the same protection in terms of capital gains tax exemption what Mauritius and Singapore treaties used to offer. The protection being that that if we interpose a Netherlands entity in between the US and the Indian target, then if the shares of the Indian target are sold by that Netherlands holding company to another non-resident company, then as of now and as of the provisions stated right now in the double taxation avoidance agreement between India and Netherlands, there will be no capital gains tax payable by the Netherlands holding company on sale of their shares to another non-resident company. But mind you, this would be applicable only if what the treaty provides for is only if the shares are sold to another non-resident entity. So if it is going to be sold to a resident entity in India, then the capital gains tax exemption will not be forthcoming. Now, there is another tax rule that needs to be kept in mind when we are doing share sales, albeit at an indirect level. It's not directly of the Indian company, but if these thresholds, what we have mentioned out here, if the assets situated in India represents more than 50% of the overall deal value, or and if the value of the assets located in India exceeds 100 million, only then will the non-resident doing a global deal which has an India presence will be subjected to and be liable to pay tax, capital gains tax in India. So these are the few important points that should be kept in mind from a tax perspective. Moving on to employment law considerations. Under employment law, we have both central legislations as well as state-specific legislations which deal with employment matters. So it's very critical to have robust employment agreements in place, not only in terms of enunciating the terms of employment, but also in terms of IP protection, assignability of IP, which we have seen to be a key factor for tech deals in India. There are certain mandatory requirements that need to be complied with in terms of maternity leaves, payment of bonus, gratuity, provident funds for employees in India. So broadly, the employment law characterizes people who work into workmen, non-workmen, consultant categories, and contract laborers. Those are employees recruited by another agency but doing work for the foreign entity in India. Consultants would mean independent consultants who would be on the rolls, but as an independent consultant of the company in India. A key point to note is that only the workman category is afforded statutory protection under Indian labor laws, whereas a non-workman, and whether he's a workman or a non-workman, it's more of a functional test that has to be determined. For non-workmen, what needs to be kept in mind is that the terms of his employment would be under the terms of his employment agreement. So there is no statutory protection afforded for a non-workman category. We need to be mindful, besides, of course, assignment provisions, also to lay down robust provisions on confidentiality obligations, which also forms a key part in employment agreements. So what we have seen is that typically in acqui-hire transactions, because of the assignments not being kept and not being done from time to time, often we have insisted on CPs or closing conditions to be of assignment agreements to be drawn up by the employees in favor of the target Indian entity that we propose to acquire, or if there's a services agreement with the US entity and there is an acquisition at the US target level, then assignment should be forthcoming from India. The reason why we say that is until the and that comes to the next slide, that until the assignment is complete, then the owner, until then, the owner of the IP is the creator of the IP. That would be the employee. So that's a very critical point that needs to be kept in mind. And often we have seen deal timelines not being met because of all these assignments not being in place, and they have to create all of that prior to closing of the transaction. And so again, coming on to the next slide, deed of assignments for patents are required to be executed in writing and to be registered with the patents registry, and must specify the nature of the interest that is being assigned. Then the deed of assignment of a copyright it's needed to be executed in writing, but it's not mandatorily required to be registered with the copyright board. Trademarks, again, need not be mandatory registered in India. So we have in India a fairly robust system of protection of IP and the granting of injunctions for violation of or infringement of intellectual property in India. Coming to anti-bribery compliance, and this is what we have seen, and as a practice area also, we are doing a lot of white-collar crime investigations practice within the firm. And what we have seen, and that takes me what I mentioned in the cultural issues, on the slide on cultural issues, that often we see promoter owned companies not being compliant with the anti-bribery regulations of India. So more often than not, we again have to insulate the predecessor liability from moving on to the successor entity. So as a result of which asset transfers and business transfers are more sought after. Now we have a legislation by the name of the Prevention of Corruption Act, which is a key legislation on anti-corruption in India. Now, unlike the FCPA, which has extraterritorial jurisdiction, the Prevention of Corruption Act only has its jurisdiction confined to India. Now, the corruption is penalized in the context of giving or accepting of bribes from public servants. And the public servant, it's between a person giving or accepting a bribe with a public servant. The Prevention of Corruption Act not only penalizes the bribe giver, but also the bribe taker, and also the bribe giver, and even the middlemen who are influencing the public servant to take a bribe. So we have been instrumental in a lot of investigations, in certain recent times, where US corporations which have set up base in India have been embroiled with, acts on the part of external consultants or their employees giving bribes to public servants, and we have navigated that through, in terms of having interviews, having policies and procedures being in place, to really ensure compliance of the anti-bribery regulations. So that brings me to the end of the presentation. I'll be happy to take questions that you all may have on these topics.
Rukshad, one question that came in was, what are the current and emerging legal enforcement policies in India, and general risk tolerance?
So enforcement policies in India, I mean, we need to, I think, in terms of enforcement, what I mentioned was that we need to really look into contracts, contractual protections under the contracts, and of course, resort to the arbitral mechanism, as well as there are interim release from the courts that would be forthcoming for enforcement of a particular on a particular situation.
And how in general would you litigate and enforce collections in India?
Sure. So the way it would work in terms of collections in India is that if we have a judgment in the US, okay, since India is not a reciprocating territory, we will first need to have fresh execution proceedings and have a judgment from the Indian courts in India to attach those assets in India. If we have an arbitral award, then the execution becomes even simpler in terms of directly executing and just filing for execution proceedings for that arbitral award. And post that, we would be entitled to attach those assets, sell and recover those proceeds. And then in terms of repatriation of those proceeds, we would need an approval from the authorized dealer bank or the Reserve Bank of India to remit those proceeds back to the US. So that's in a nutshell as to how we would go about with execution and enforcement of judgment debt in India.
And you mentioned that there's emerging considerations in terms of data privacy. Do you see, I know, countries seem to be moving toward like a standard contractual clauses model with required agreements. Do you foresee anything specific in terms of data privacy?
So I think, we have to have robust confidentiality provisions, as well as data privacy policies on the websites, as well as, to really have a defense on that front. But of course, I mean, we are quite positive that we should be having, given the way the legislations are moving in India, we should have this, because there is a lot of, representations being made by foreign investors to have this data privacy legislation enacted at the earliest. But even now, it does regulate prevention, data privacy. But we need to have these checks and balances in place.
And I know you had touched upon cultural issues at the beginning of the presentation. And someone has asked, are there any caste system or gender considerations to keep in mind?
Well, there are different in terms of for the female gender, we are seeing a lot of policies in place and also enactments in place in terms of prevention of sexual harassment, as well as maternity benefits. So yes, we do have things that takes care of the female gender, and and to comfort those situations. And those are required to be mandatorily followed in India.
And I'm sorry, I'm looking at the questions coming in. This is a little more broad, but what would you say are the major risks for sales contracts for services in India?
So the major risks for sales contract and services in India is of course, besides of course the contractual protections that you have, I think a key point to navigate around is that it should not lead to a tax consequence of the US entity in India, in terms of, if you are appointing somebody wholly and solely executing contracts for you guys in India and negotiating that and being the front, that could expose the US entity to a permanent establishment tax risk in India, which really should be avoided, because if it leads to that, then the US corporation could be subjected to a very high tax rate of about 44% in India. So that's to my mind a key consideration that needs to be kept in mind for sales and distribution contracts in India.
Jumping back, is there a minimum number of employees that a company needs to have in order to be subject to the regulations requiring certain benefits and protections for employees?
Yes, different regulations specify either a number of 10 or 20 for those benefits to kick in. So for the payment of bonus, for the payment of gratuity, and for insurance, there is a different. Between 10 to 20 employees, that's the norm.
And are there any emerging labor and employment law changes resulting from the pandemic?
Sure. So we are on the anvil of a labor code that's going to really congregate different labor legislations and make it more simpler. And in terms of it's going to be, in fact, it's going to really ease out further for foreign corporations to do business in India. It's really going to spell out what are the key considerations to be kept in mind, because mind you, we have got certain labor legislations which are very archaic and which are very old. Of course, there have been certain tweaks here and there, but not many over the past couple of years in India. So the government recognizes the fact that the time has come to really have a new code in place, which is expected shortly.
That's good to know. And I'm sorry, I had mispronounced. Are there certain caste system considerations to consider when doing business in India?
Well, I would not say so, because I think largely, for good or for bad, the government had been criticized, in terms of, preference to different castes. But I think whilst doing business in India, I think they are pretty much equaled, and we have not seen any discrimination on that front.
Do you have any thoughts on employer of record services provided in India if a company wants to avoid having to establish direct operations?
I'm sorry, I could not hear that question.
Oh, sure. No. Do you have thoughts on, employer of record, I think it's PEO services provided in India? If the company wants.
Yeah, sure, of course. We have seen, as I mentioned, another set of employees would be contract laborers, and those would be the PEO type of arrangements that we talk about, where the employer would be the PEO, the contract labor organization, and that organization would be liable to meet all the employment dues for the employee. And whereas the employee, there would be just a services arrangement between a PO arrangement between the US company and the contract labor organization in India. So yes, we have seen PO arrangements, and in fact, there are a lot of acquisitions also emanating from on the PEO space, where employees which are hired through the PEO arrangements, they are being lapped up by foreign-owned Indian targets. And in terms of putting in touch, if anybody needs any references, please feel free to reach out to us. We'll be happy to recommend certain PEOs as well.
That would be great. Okay, well, I believe that's all the questions we have. I'll wanted everyone to know that, Majbudar will be back on November 30th for another webinar. We are sending CLE certificates in the coming days. And of course, please reach out to Rukshad if you have additional questions. Thank you, Rukshad. This has been really informative. I've learned a lot. Thank you.
Thank you. Thank you, everybody. Have a good day.
Thank you.